I have a plethora of rights that are granted to me from God, the Human Declaration, from the Constitution, and so forth. I was attacked by some people, and I was protecting
Sir,
my life.
I know you
One
don't
second,
want my
one
representation, but
second. Thank you. No, ma'am. No, ma'am. No, ma'am. No,
I would
ma'am. Please
advise that
don't.
you not
Please
talk about
don't.
anything that happened.
Please don't. I have reiterated that Latavius Stretch Out Thornton is a nonprofit organization. I am not a surety. I am shoulders.
Do you have a medical marijuana card?
Mr. Thornton does not know.
Was the GPS ordered if he was released?
That's not necessary.
No.
I have
Okay.
children.
Just a minute. All right.
This sovereign citizen appeared in court the other day and he made a massive mistake. He was there facing charges for assaulting 3 police officers, and he stood before the judge claiming that his name is an LLC nonprofit and insisting that he is innocent. The guy seemed completely unhinged and would not stop talking throughout the entire hearing, going on in non-stop rambling the whole time. Let me know in the comments if you think he might be mentally ill or something, because at this point I genuinely cannot tell. How do people like this even reach adulthood without someone stepping in? Anyway, let's get into it and watch this sovereign citizen get completely shut down in court.
I'm Melissa Vachon with the Office of the Public Defender. Your Honor, I would note for the record that I am present and I did speak with Mr. Thornton. However, he is declining my representation at this arraignment.
Okay. And Mr. Thornton, could you state your name for the record, please?
I will object to being called Mr. Thornton. I am, for the record, my name is Shoulders. I am here as legal representation for Latavius Stretch Out Thornton, which is a nonprofit organization.
Your Honor, I'm looking at his file from 2022. I think he was sent to competency back in 2022, and it looks like it's going to be the same issue today. It's my understanding that he might have a bench warrant out for his arrest for sentencing. He pled guilty to, I believe, attempted RNO in November 8th of 2022, but he failed to appear in December 2022. And looking earlier in the files, I believe he was sent to competency as well. And it looks like this is going to be the same issue. So if the court is inclined to send him to competency, I'd ask for that.
Objection again, Your Honor.
Everything comes to me. You're going to get your turn. Okay. But I have to run this in sort of an organized fashion, in part for you, because if you want to appeal, you want a transcript that is coherent and readable. Okay.
I'm sorry. I don't know. Were you speaking to me or
yes,
to
sir,
Mr. A?
Mr. Thornton? So if you want to appeal,
Please want. I just want the record to be correct, and there was no objection. There was no objection to the statement that I made about Mr. Thornton, about Latavius Stretch Out Thornton being a nonprofit organization, and I was just objecting the points that the attorney prosecutor made.
Okay.
I just.
But
yes,
there aren't objections at arraignment. There aren't objections at arraignment. And I am going to call you Mr. Thornton because that is the name that you have been identified as, and that is the name the charges are under. No, Mr. Thornton. So, I mean, the other option is to call you defendant, which is true. You are the person defending yourself, but that sounds kind of rude. So I'd rather call you Mr. Thornton. So I want to make sure that we treat you with as much respect. Here's why we have this hearing. You have, under the Constitution, a Sixth Amendment right to know the charges against you. So we have this hearing for that reason. So I want to make sure that you get all of your rights and know everything that is available to know about this case right now so you can defend yourself. That's the whole purpose today. To give you the information you need so you can defend yourself with or without counsel as you wish, okay? We're going to do 5 things this afternoon. First, I'm going to read the charges against you, including the maximum possible penalties, because you have a right to know them. Second, we're going to talk more about your rights. Then, I'm going to enter a not guilty plea on your behalf. I'll give you the opportunity. Well, no, sir. So just a minute. Okay, so you're going to have the opportunity. You can stand mute or plead not guilty. We'll come to that in a minute, okay? So that's the third thing we're going to do. Then we're going to talk about dates when you return to court. You're going to get those in writing. Lastly, we're going to talk about bond or bail.
Can I please ask?
Because here's the thing. I don't want to be disrespectful to you.
Right, absolutely.
I know it feels disrespectful, but here's why. Here's my concern.
These sovereign citizens truly do not care whether they are being disrespectful. It is almost as if they believe the court operates on their schedule or that they are the main character in some kind of legal drama. Honestly, in my opinion, and this may sound a bit harsh to some people, let me know if it is too harsh, but judges should simply tell them to be quiet, stop talking, and quit wasting everyone's time, especially when the judge is clearly trying to move on to the next case. There is a time and place to speak, of course, but this guy consistently chooses the absolute worst moment to start talking. If he wants to give his little speech, he should save it for the actual hearing when it is at least somewhat relevant. This is exactly why Zoom court often turns into chaos, because people become far too comfortable misbehaving behind a screen. They act like they can talk over everyone as if it were just a group FaceTime call or something similar.
I don't want you to say anything that could come back to haunt you later. So that's why, and this is true of every arraignment I do, I tell people right at the beginning, if you try to speak, I'm going to shut you down. And it's not to be disrespectful, and it's not because the case has already been decided. It's to protect your innocence and your interest going forward. So for that reason, I'm going to do most of the talking here.
That's fine, Your Honor. I'm fine with you doing most of it. But please, to protect my free speech, could you please not mute me? I have no intentions of disrespecting your courtroom. If I speak out of turn, could you just simply let me know? And
Okay.
I am aware that I am innocent until proven guilty, and that something I say could, like you said, come back and haunt me. I'm well aware of that for Taylor Straight Shot Thornton. However, I do still need to express correctly, and if I'm capable of settling this matter now, why can't we do that? I have more than just the Sixth Amendment right. I have a plethora of rights that are granted to me from God, the Human Declaration, from the Constitution, and so forth. There's a plethora of rights that have been granted onto me. So I don't just want to rely on the few far in between. I would like to rely on all my rights and abilities, and if possible, take care of all these matters in the most dignified and respectful way to keep the court's dignity and my dignity as a man. And furthermore, as a preservation of my innocence, I would like, until proven guilty, I believe that is pertinent that the innocent factor be imminent here.
Absolutely. So here's what I'm going to tell you. And I tell this to everyone at this stage. The most important thing I can tell you this afternoon is that you are innocent. You are innocent unless you remain innocent unless at some point you plead guilty or are found guilty beyond a reasonable doubt at trial. And I say unless for a reason, because it's different than until. And now I'm going to read the charges against you because you have a right to know them. Okay? You can't really defend yourself unless you know what you're accused of. Maybe you remember being a little kid and going to the principal's office and not knowing what you might be in trouble for. No? Okay. Well, you were probably a better little kid than I was. But I'm going to read the charges against you. It's going to take some time reading all the way through them.
Before you get to reading, can I make one statement, please?
Well,
Your Honor?
You can, but let me read through these first, okay? Let me read through these first because I want to make sure I cover everything. The other thing is judges use scripts. And the reason we use scripts is to make sure everyone gets all of the information and to make sure we treat everyone the same.
I'm aware of that, Your Honor. And that is why I feel it necessary for me to make certain things known for Lieutenant Straight Thornton, for that the script so we can stay in honor. Once again, I have no intentions on dishonoring the courts. I'm even here to surrender all of the interests of Latavius Treshaw Thornton to the courts. I have those full intentions. And so that you guys can be safe from all liability of Latavius Treshaw Thornton as his representation. That is the only reason why I speak in the way of please refrain from calling me Mr. Thornton and certain things, because it's pertinent for you guys to know I've already been treated as the surety. I am not the surety. I'm really shoulders. Like, if you guys meet my people, you will find out I'm really shoulders. Latavius Treshaw Thornton is really a nonprofit organization, and I am not a surety for it. And it is a company, and it does not profit. So with that information, I understand that the script goes a little different, and I understand that I have the right to let it be known that I'm not the surety, and nobody has. I'm sorry, and
Okay. All right.
Yes,
So
ma'am.
here's
Your Honor.
here's the
sorry.
thing. That's okay. That's not an issue.
So basically, this guy is standing there saying, "My name is Shoulders, trust my word, even my people can tell you my name is Shoulders." But Shoulders? What kind of name is that, first of all? The law does not care whether you claim to be a helicopter, a toaster, or some kind of transformer. You are going to be called by your legal name in court. This is not a nickname contest, it is a legal proceeding, not a high school talent show. The craziest part to me is that the judge is just sitting there allowing him to go on and on like it is an open mic night at a coffee shop. Come on, get control of the courtroom, because this is honestly becoming embarrassing. Everyone is just sitting there listening to this nonsense as if it is completely normal, and I am over here wondering how he has not been muted yet. We are practically one strange sentence away from him claiming he identifies as a traffic cone with diplomatic immunity. Let me know in the comments what you think about this judge so far.
So in count one, you are accused of police officer assaulting, resisting, and obstructing. And the specific allegation is that on or about March 9th, 2025, at Cary Street and Lake Lansing Road in the city of Lansing, zip code 48912, you did assault, batter, wound, resist, obstruct, oppose, or endanger Kayla Bevere, a police officer with the East Lansing Police Department, that the defendant knew or had reason to know was performing his or her duties, contrary to Michigan law MCL 750.81D1. This is a felony punishable by up to 2 years in prison and or $2,000 in fines. In count two, you are accused of assaulting, resisting, or obstructing a police officer, again, on or about March 9th, 2025, at Cary Street and Lake Lansing in the city of Lansing, zip code 48912. Specific allegation is that you did assault, batter, wound, resist, obstruct, oppose, or endanger Chris Shattuck, a police officer with the East Lansing Police Department that the defendant knew or had reason to know was performing his or her duties, contrary to Michigan law MCL 750.81D1. This is, again, a felony punishable by up to 2 years in prison and or $2,000 in fines. Lastly, in count three, you are accused of, again, assaulting, resisting, or obstructing a police officer. And the specific allegation is that on or about March 9, 2025, at Cary Street and Lake Lansing Road in the city of Lansing, zip code 48912, you did assault, batter, wound, resist, obstruct, oppose, or endanger Colin Lemire, a police officer with the East Lansing Police Department that you knew or had reason to know was performing his or her duties, contrary to MCL 750.81D1. This is, again, a felony punishable by up to 2 years in prison and or $2,000 in fines. Now, how do you wish to plead?
I don't. You said a lot, so can I address them part for part first?
No, not right now. So here's what I'm gonna do. Here's what I'm gonna enter a not guilty plea on your behalf, and here's why.
Can I ask you this first before you enter that plea? If me giving you a plea right now, will that be in response to everything that you just said?
Nope. So a plea would have you pleading. Would have you pleading guilty
I'm sorry.
to all those charges. We've got some back and forth here. It kind of sounds like we're underwater. So a plea would have you pleading guilty to those crimes, 3 felonies, without having seen the evidence against you. So you can stand mute and the court enters a not guilty plea, or you can say you want to plead not guilty and you'll be not guilty. Then what happens next, and here's why, then you have a chance to get the evidence against you and to consider it, among other things.
It's a bit more to it, Your Honor. That's the issue. So based off of the things that you stated, that's not what my understanding is. From my understanding is I was attacked by some people and I was protecting
Sir,
my life.
I know you
Okay.
don't want my representation, but I would advise
No, ma'am.
I would
Please
advise
don't.
that you not
Please
talk
don't.
about anything that happened.
Please don't, ma'am. I appreciate that.
No, this guy is a complete idiot. The prosecution is probably rubbing their hands together like a cartoon villain right now, just waiting for the chance to tear him apart. It could not be more obvious that he desperately needs a lawyer after the mess he just said. This is not a YouTube apology video, it is a courtroom. I see this happen far too often, with sovereign citizens showing up to an arraignment hearing and immediately launching into a rant about how they are innocent, but that is simply not how the justice system works. You do not earn bonus points for being loud and wrong. I genuinely do not understand why they will not speak to a lawyer for even 5 minutes just to get a basic idea of what they are walking into, because discussing the facts of a case like that is one of the worst decisions you could possibly make. At this point, it feels like something is seriously off, whether it is delusion, denial, or pure ego, because they seem completely disconnected from reality. Let me know in the comments what you think it is, since I honestly have no idea.
I'm aware of why you're doing that, but I'm aware, like I said, me and the judge, I told her something that I might say could come back to haunt me. I'm already aware of that. So thank you so much, Miss Melissa, but please do not intervene. Once again, back to you, Your Honor. From my understanding, I was assaulted, and I am shoulders. Once again, I have never told anyone. Wait, I don't want you to mute me, Judge. This is going back to this situation. Okay, thank you. I never told anyone that I am Latavius Trayshawn Thornton. Not one time. I have reiterated. I am shoulders, Latavius Trayshawn. Not just to you, Your Honor. That's so to be redundant for the record. Okay. I have reiterated that Latavius Trayshawn Thornton is a nonprofit organization. I am not a surety. I am shoulders. I am appointed to be an administrator for Latavius Trayshawn Thornton. No, that's why I'm here, but not a surety for Latavius Trayshawn Thornton. Furthermore, Your Honor, my understanding is I was attacked and assaulted, and I'm not sure if I could let that be known to you so that we can make that case come about, because I would like to seek forward that using the evidence from all the evidence that they have gathered. I would like to use it in my assault case against East Lansing Police Department and its agencies.
Now, next up, we have some dates when you're going to return to court. And let me just pull those up here. Okay, go ahead.
Yes, I just wanted to speak on my previous court history and let you know why it may look the way it looks.
Okay, no, here's the thing. I'm going to ask you to not say anything because I don't want to accidentally become biased.
Gotcha.
So, all right, so here are the dates. All right, you're going to come back for a probable cause conference at 8:30 a.m. March 21st. Now you're going to get this in writing, okay? 8:30, March 21st. We're going to move on to bond or bail. So would you like to be released on bond or bail?
Could you explain the difference to me, please?
Your Honor, I was going to ask for a bond. People
Okay.
have.
We're going to let Mr. Anid go first. All right, Mr. Anid.
The people are looking at MCL 765.6. Some of the factors to
Now
consider.
you're cutting out. I'm sorry. Go ahead.
Okay, if you said something like that, would it make you biased? Couldn't you be speaking to make you biased?
Well,
right now?
I'm going to come back to you in just a minute, okay?
Okay, no problem.
All right, Mr. Nid, I'm sorry you were cutting out, but please.
Your Honor, the people are looking at some of the factors to consider bond. The people are asking for at least a $25,000 cash surety and GPS tether if he does post bond. You're looking at the seriousness of the offense charge, the protection of the public, previous criminal record, and the dangers of the person accused, the probability or improbability of the person accused appearing at trial of the cause. All those factors are not in favor of the defendant, Your Honor. He failed to appear for sentencing in, I believe, circuit court. And again, Your Honor, if the court has updated lien, if you can see if he has a warrant from a couple years back, that's for pleading for attempted resisting and obstructing, is what my note indicates. Protection of the public, Your Honor. This case involves assault on officers. I think one officer got punched in the face. The previous criminal record, he has 4 criminal histories from 4 different states, Your Honor, pending from.
Okay, no, he's going to get, and then I'll hear from you, okay?
And his probably. Your Honor, lastly, he failed to appear for several years on sentencing. He's not going to appear for this case if he gets released. I just asked for a high bond and a GPS tether if he posts that bond. There's a lot of risk to the public in this case, and he obviously he has ties to Indiana, Kentucky, Georgia, and one other state, Your Honor. This is a problem.
Okay.
Thank you.
Okay, now
Before we get to bond,
okay, I'm going to give you a chance, but here's the thing. Because there are certain keywords, because there are specific things attorneys ask for, do you want Attorney Vachon to address this on your behalf? Because she's really good at this. I will tell you, she's really good at this.
can I say some things to Attorney Vachon before I make that determination? Right here.
Yes, Your Honor. Could we take a brief recess and I could have a breakout room?
Okay, so you're going to be in a breakout room with just Attorney Vachon. Then we're going to come back. Nobody's going anywhere until after you've had a chance to come back. Okay, one moment, please. We'll put you in a breakout room. Thank you.
Thank you.
Okay, so I'm going to start with Mr. Nate has spoken. I'm going to start with Attorney Vachon. Attorney Vachon, anything from the breakout room?
No, Your Honor. The defendant will speak for himself.
Whoa. Whoa.
Okay, sir, please proceed.
Okay, Your Honor. Thank you. Mr. Thornton is not a flight risk.
That was literally the first thing he said, that he is not a flight risk, and honestly, if that is your opening line, it immediately raises red flags. Generally speaking, when a defendant volunteers a statement like that without being prompted, it suggests there may be something they are trying to hide or deflect from. In this situation, considering he allegedly assaulted 3 police officers and even struck one of them in the face, it is completely reasonable for the court to view him as a potential threat to public safety. Any judge would have to take the seriousness of those actions into account when evaluating risk. Making that kind of preemptive defense only adds to the concern. And just wait until you hear what he says next, because it is not only unexpected, it genuinely makes you question how seriously he is taking the entire legal process.
He has multiple properties in the Michigan and the Lansing area that keeps him here. Also, he has a lot of things he do here. He's a coach for 4th grade, 5th grade, 6th grade basketball teams, and they play year round. He's also a mentor to young children and to people who have had traumatic situations. They call on a daily. He's a counselor to the community and to the public. Furthermore, he's not a danger to the community or based off of his innocence, and he's not a threat to anyone in the society. He is actually beneficial to Mr. Thornton is actually a beneficial role in the community, and kids and multiple different areas of people, they look up to Mr. Thornton, and they will attest to his character as an upstanding, nonviolent, peaceful individual who brings smiles and love to the community. And he, once again, may I reiterate, is not a flight risk. Yes, he has ties to other places, but those ties are not as pertinent as to the ties of where he originally was born and reside and has grown as a part of this community and in a very effective way.
Okay, thank you. That's very well said. Sounds like Mr. Thornton really has a lot of good qualities. Okay, so I am looking at the file, and I want you to bear with me a bit. There was a song when I was younger. When I was in high school, there was a popular song that said, "Cruel to be kind." Okay, I'm looking at this, Mr. Thornton, and there's a warrant out of 30th Circuit Court, downtown, East Lansing. Okay.
Yes.
And this is from 2022, and it's a statewide pickup, no bond with extradition. So here's what I'm going to do. I'm going to come back to that in just a minute. I'm going to set a money bond of $10,000 because all of the days that you don't post that bond, you will get credit for the time. If I gave you a cash bond, what would happen is Ingham County would pick you up on this old warrant and hold you until that case was resolved. By setting a cash bond on this, you get credit for the days you're in. Then, when that's resolved or close to being resolved, I will reconsider the bond amount. We call that making a bond motion, and I'll entertain that. But right now, this is cruel to be kind, okay? I know it's not what you want, but having been around the law long enough, this means they're going to keep you in custody for some time. So I want to be sure that you get something for it. Now, I'm going to put some other conditions on the bond for when you're able to bond out. And you're going to get these in writing, but I need to read them to you, and they need to be part of this record. So if you want to appeal, it's all here for you so they can evaluate whether I did this right or not. So number one, if you post bond, you may not leave the state of Michigan without prior permission from this court. Number two, you are presumed innocent, but the court says we have to tell you this right now. You may not commit any crime while released. Doesn't mean I think you're going to, but you have a right to know that. Number three, you must immediately notify this court in writing of any change of address or telephone number. Then you must not use alcohol, recreational marijuana, or any illegal controlled substance. If you have any medications, you must take all medications as prescribed. Do you have a medical marijuana card, sir?
I'm sorry?
Do you have a medical marijuana card?
Mr. Thornton does not know.
If we actually step back and look at all of this, it is honestly just ridiculous what this guy is doing right now. There is no way he truly believes he is going to beat this case by claiming his name is an LLC. You are not a business, you are just creating more problems for yourself. It is unbelievable that someone could walk into a courtroom and sincerely think that saying, "I'm not a person, I'm a corporation," is some kind of legal loophole. What has the world even come to? When I was a kid, I thought that by 2025 we would have flying cars, teleportation, and robot butlers, but instead we have sovereign citizens trying to trademark their middle names in Dodge Chargers. It is sad, but it is also pretty funny at the same time. Overall, I am just glad the judge set his bond at $10,000, because if he had walked out with nothing more than a slap on the wrist, I would seriously start questioning reality.
Okay, so may not use marijuana at any time and may not apply for a medical marijuana card without prior permission from this court. May not possess or purchase a firearm or other dangerous weapon. May not use any object as a weapon. May not engage in any harassing, violent, threatening, or stalking behavior toward anyone. May not have any contact with Kayla Bevere, Chris Shattuck, or Colin Lemire. Can't use have anyone else contact them. Can't use any social media to look them up or try to contact them. Okay?
I don't have social media.
All right, now, you must contact pretrial services by 4 p.m. on the day you're released from custody. All right, anything further, Attorney Vachon?
No, Your Honor.
Smith. Okay, anything further, Attorney Anid?
Yeah, so I must have misheard. Was there a dollar amount to the cash bond?
10,000.
10,000 cash charity?
Yes, sir.
Thank you. And then lastly, was the GPS ordered if he was released? If not,
That's not necessary.
No,
I have
okay.
children.
Just a minute. All right. I'm just going to answer his question. No, I'm looking at the circuit court bond, which, no, it was not. Okay. Now, sir, what would you like to say?
First and foremost, how much, you said that if for each day that the bond isn't posted, there would be a credit amount. I'm not, I just want to throw this out there for Lee Taylor Thornton. Once again, he accepts that offer for the credit amount to be $1,000 a day. And furthermore, he accepts other offers from the prosecuting attorney's office if they are willing to go day by day with Mr. Thornton
Well,
if he's incarcerated.
well, that's good to know, but that's not on the table just yet. Okay. And so what happens is you get credit for time in this case with that bond amount. Otherwise, if I were to give you what's called a PR bond to say you can go, then you wouldn't get any credit for this time while you're waiting for that old case to be resolved. So, okay. So you're going to receive all of this in writing, and we will see you back 8:30 a.m. March 21st.
Yeah, if this guy does not change his attitude soon, I would be willing to bet he is looking at a solid 2 years in prison for those charges, especially with assaulting officers included, because judges do not take public safety lightly. Claiming you are an LLC is definitely not going to work as a defense strategy. We will have to see how everything plays out in court. Make sure to subscribe if you want to catch part 2, because I will track it down and post it as soon as I can, so stay tuned since it is probably going to get even crazier. Honestly, it sometimes feels like society is getting dumber by the day. How did we go from moon landings and internet breakthroughs to people yelling, "I don't consent," in court as if that is a legitimate legal argument? Maybe it is just the sovereign citizen mindset, or maybe it is social media influence or even politics. I am not really sure. Let me know what you think in the comments, and tell me your thoughts about this hearing as well. He was clearly not very bright, but at least he managed to stay somewhat respectful. Anyway, I am going to wrap it up here. Thanks so much for watching, and take care.